Hi, and welcome to the Hoffline, your online hotline direct line to the women-only attorneys at Hoffmer Family Law. My name is Katie Carter, and I'm so glad you're here. I'm an attorney with Hoffmer Family Law, a Virginia-based family law firm dedicated to representing women exclusively in divorce, custody, and child support cases. And I'm here today with Ashley Pack to talk more about going to court, basically what to expect and what people don't know. So, Ashley, thank you so much for being here with me today.
Hi, thank you for having me.
I'm
I love
excited. I know
this
it's been
one.
hard. It's been hard to catch up because you're so busy going to court, but I know you have a lot of
Yeah.
expertise that will help women as they begin to make decisions about their cases and moving things forward. So I'm just going to jump in with the first question. What is it that you think that women don't know about going to court in a divorce or child custody case?
I think that a lot of times they don't know that they're going to have to testify, for one thing. That can be challenging, and it's something that comes as quite a surprise to a lot of people. When we sit down and talk about preparing for court, I often will say things like, when I call you to the stand, and they immediately kind of shut down or get upset or I don't want to testify, this wasn't what I was expecting, I didn't think I was going to have to speak when we're in court, I thought you were going to do that for me. But I do think that that comes as quite a surprise to a lot of women, that they will have to testify in their own case and on their behalf. But with enough preparation, it's certainly something you can be prepared for and overcome those jitters. And we certainly work on that to get ready for court. So that's one big thing. And then I think that um, how much time it takes to get divorced is often surprising for a lot of women. Um, I do think as women, we take our time making such an important decision. There's often children involved and a lot of things that have to be considered. And so by the time they get to that place of feeling comfortable enough to say, I want to get divorced, they're ready to get that process going and be done with it. And
Mhm.
so it does come as quite a surprise, I think, the time that it's going to take to get there, because we have to sometimes have several hearings, and there are things like discovery that have to take place, but they're important pieces, and they have to be done to prepare for the case. And so that's a surprise, but an important part of their case.
Yeah, I think that, yeah, it's
Yeah.
important. I think it's important too to remember that, especially if you've never been in this position before, that the feeling of like showing up in court on the day and be sitting across counsel table from your soon to be ex-husband and not I mean having to not just testify but be cross-examined and
Yeah.
speak, clearly and concisely about all the things that have brought you to this point while he's sitting across from you and looking at you, and just how difficult that is. When I was a brand new baby lawyer and I was just shadowing someone else, and we went to a pendente lite hearing, and I mean, I was shocked to watch the client experience it, but she practically hyperventilated. Like, it was a huge moment for her, and, like, the bailiff, like, came in and was asking us, "Do I need to call an ambulance or something? Like, is she
Yeah.
gonna be okay?" And luckily, I was there with, a more senior attorney at the time, and I was just kind of, like, holding her hand and, like,
Yeah.
trying to talk her down and bring her through it, but it was just a really overwhelming experience. So I do think just holding space for that experience and sharing with your attorney how you're feeling and what you're going to need to kind of get through those experiences and get out what your attorney needs you to get out in
Yeah.
your testimony and in all the evidences that's coming forth. You need to really be able to have those conversations so that both you and your attorney can prepare for what that's going to be like, because
Absolutely.
it's overwhelming for a lot of people. I know
It can be.
it would
Yeah.
be for me. I think that's a
Yeah.
fair thing to say.
Yeah. Yeah. I think I don't know how I would react in that situation, but I think it
Yeah.
would be overwhelming and scary, you know, especially, where there are allegations of fault and you have to testify about those fault grounds and things like that. That can be a little bit scary. And
Yeah,
so preparation just becomes that much more important in
it
those
does.
cases.
It does. Do you
Yeah.
think that there are early signs that tip you off when you're, initially meeting with a woman that tells you, like, this is a case that's going to be litigated versus this one that's more likely to reach a settlement?
Always surprised about what our clients are willing to when our clients are willing to work towards a settlement, but I think that oftentimes clients who are less likely to work towards settlement become more likely as time goes on.
Yeah.
I do think that those clients that come in with extremely unreasonable expectations, certainly not unreasonable to them, but unreasonable in the court's eyes. They're going to have to often be told by a judge that their expectations are unreasonable. And
Yeah.
so it's unfortunate, but we can't always get our clients to a place of settlement. And so when you go to court, you just have to explain to the judge what the expectations are, why those expectations are in place, and hope that the judge sees it your client's way. Sometimes they do, and sometimes they don't. But I do think that those unreasonable expectations often lead to litigated cases.
Yeah. Well, and of course, unreasonable expectations can exist on both sides. Uh,
Oh, for
it's
sure.
it's it's definitely hard to navigate. Sometimes I feel like we're the ones who are like, "Come on, we're here, we're showing up, we're ready to negotiate something,"
Yeah.
and the other side just isn't willing to. And it can be on our side too, especially when, you don't know your family law attorney usually very well. Generally speaking,
Right.
you're not friends before you start representing someone. So getting advice that doesn't necessarily jive with your intuition or how you feel like things are work out will work out. What even maybe even what your soon to be ex-husband has kind of promised you. Like if you feel
True.
like there's a difference between what he said and now what's happening, it can be hard
Yeah.
to let go of, you know, feeling entitled to something whether you are or whether you are not.
And that often happens, or just even the way that you've been living as a couple, you
Yeah.
expect maybe sometimes custody is going to go a certain way because that's the way it's always been, but your spouse has a different idea in mind. And so now, it may not seem unreasonable to you
Yeah.
to expect to have maybe primary physical custody in a case because you've essentially had primary physical custody all along. But, in today's time, that isn't always the situation, and judges like to move towards 50-50. And so it's explaining to the judge why it shouldn't be 50-50. And sometimes that becomes more difficult when you have a spouse who really hasn't done anything wrong, but you've just kind of stepped into that role as what we sometimes call the default parent, you
Yeah.
know. And so you want to continue to be that. And sometimes it just doesn't work out that way. But um, we can't always get clients on either side to
Yeah.
see, that is the way that the judge is going to probably more than likely um, come down on their case as far as custody is concerned. So I
Yeah.
do think that those custody cases are the more difficult cases when it comes to expectations.
Yeah.
I think that spouses or parents often do have agreements during their relationships or even after their relationships. But when it comes to court, those agreements start to change, and they can change for any number of reasons. Sometimes it's, I don't want to pay child support, so I'm going to
Yeah.
fight for 50-50 custody.
Yes.
We see that. And so then it's fighting against that and explaining to the judge that, but you can't say it's because he doesn't want to pay child support. So
Yeah, he's like, "No,
you have
no,
to
I just
find
wanna
all
be a
the other
good
reasons.
dad."
Yeah. Yeah.
Yeah,
So,
but then you're like, "Well, where were you when?" Right? Like, "Where were you when,
right.
because we're sick and I'm taking off work and I'm the one who is handling
Yeah.
everything, and
Yeah.
now you're telling me 50-50 custody," especially when it's important. Like, you probably, if you're here, you've probably done some research into Virginia law, and Virginia is not an automatic 50-50 custody state. The law is just that the judges are supposed to consider all forms of custody equally. But
Right.
the reality is that many judges, especially in contested cases, like to start, not necessarily at 50-50, not necessarily at something like week on, week off, but something that gives both parents the opportunity to parent their kids. And
Right.
the way the judge is thinking about it is that custody, visitation, child support, they're all modifiable. So if this isn't working out, we can change that later. But, if you give, one parent or the other more preferential treatment in the early stages, it might be hard to then, to change that balance,
Yeah.
and hard to give the other parent the opportunity to, rise to the challenge and parent. And, as a default parent in my own personal life, I know that that would be a very difficult thing to live with. And I can understand that that's difficult advice to hear, which is why it's also really important, especially in the early stages, to interview and hire an attorney that you like and trust and that you can have really difficult conversations with about,
Yeah.
what's likely to happen, what is the, ultimate outcome going to be, so that you can make decisions about whether it's worth going to court. Sometimes you have to, but you don't always have to, and you want to make sure that the advice that you're getting from your attorney is solid advice that's going to get you, at least as close as possible to the results that you want, and
Yeah.
isn't going to make the whole process that much harder.
Yes. Absolutely. I agree.
Would you say, Ashley, that you can identify some big mistakes that many clients whose cases are litigated tend to make? Are there, ones you can really point to that you're like, oh, yep, these are the biggest mistakes that family law clients make in court cases?
I think that not sharing all of the information with your attorney that you have in your possession can be a big mistake. So whether it benefits you or doesn't benefit you,
Yes,
your attorney really needs to know it all. So either they can use it to your benefit during court,
yeah,
or they have the tools to defend against it if necessary during court, because more often than not, if you haven't shared it with your attorney, the other side is going to have it and they're going to share it with theirs. Certainly, if it's something that they can use against you in court. And
yes,
so that becomes extremely important. You really have to make sure you're telling your attorney everything. And that comes back to what you were saying about trust. You have to have an attorney that you trust enough to have those hard conversations and
yeah,
talk about the times that maybe you messed up, and that how you overcame maybe those mess ups or whatever the situation, but you've got to be able to have those conversations. So but I
mm,
do think that that is one of the biggest mistakes um, that people make when they are litigating a case, is just not providing every bit of the information that they have or know or is available to them.
yeah. I mean, it's a great way to save money too, right? Is to provide
Absolutely.
those documents to your attorney, provide them up front, provide them as quickly as
Yeah.
possible. Don't make your attorney, have to turn around and get stuff through discovery that they could have gotten from you. Don't
Yeah.
make the attorney have to send a subpoena that, maybe with a little bit of digging that you could have gotten. I think a lot of people expect, you spend several $1,000s hiring an attorney and they're going to just do all the work for you. But we don't have the ability to get all of that information
Right.
ourselves without going through some costly steps.
Yeah.
So the more you can provide, the more honest information you can provide. Again, just like Ashley said, even if it's not favorable to you, maybe even especially if it's not favorable to you,
Yeah.
making sure your attorney knows the facts and is able to address them. Maybe whether we definitely avoid them or whether we weave them into, the original testimony that you give, so that we can kind of take away the sting of them bringing it up later or bringing it up in a different way, trying to make something that is maybe not a big deal seem more damning or seem like we're trying to hide something. And that can be as simple as talking about, maybe you had too many drinks at a bottomless brunch, maybe you have a mental health issue, maybe you have, whatever is going on. If we know about it and we can address it, it was one time. Or yeah, she struggles with anxiety, but she's seeing a doctor, she's following a treatment regimen. Like, this is completely fine, it's not hampering parenting in any way. So whatever spin we can put on it to take away the sting is going to be really important,
Right.
especially when we have, a bad factor too, which almost
Yeah.
everybody does.
Yeah. Well, and I also think another thing is And along the same vein, really, it's being responsive to your attorney. And so whenever appointments are requested or emails are sent that require a response or even text messages, whatever it is, you got to respond. You've got to make
Mhm.
sure that that information is getting back to your attorney. And, we have the discovery process, and that discovery requires a lot of time, a lot of
Mhm.
documentation, and a lot of effort on your attorney's part, but also on the client's part. So you want to make sure that when those documents are requested, you're doing your best to get that handed over to your attorney so that they can timely get that
Yeah.
provided to opposing counsel in your case.
Yeah, and be using it to prepare a case strategy.
Yeah,
The more time we have to think through the facts and how everything intersects, the better our arguments are going to be, the more direct we're going to be able to be. If you get things at the last minute, it can be very hard to have a chance to synthesize all that information into some kind of coherent narrative. And that's what
right,
I think that's ultimately what going to court is about is creating a story, not in the sense that not in the sense that it's fiction, it's a true story, but creating an easy to follow narrative that shows the judge what's true and how that intersects with the law because, the court doesn't really care about people, it cares about upholding the laws. So
right.
we have to bring the law in and intersect that with the facts and then make our argument for why whatever you want should happen. And we can do that a lot better when we have as much information as possible as early as possible.
Yes, true.
What would you say, Ashley, like to a client who is just beginning the process, suspects that her case is going to go to court, and she's wondering how to begin to prepare?
I would say it becomes very important to start documenting everything.
Yeah.
Um, I know in today's time we have a lot of electronic devices that can document things on calendars or any other sort of a way that electronic devices do that. But I like a desk calendar. I often recommend that they just get one of those big desk calendars where they can fill out from day to day things that have
Yeah.
taken place because pieces move often on a daily basis in these
Mhm.
cases. And so, especially in a custody case, when you have a very contested custody case and there's issues related to parents not exercising visitation, not calling, not communicating at all with the other parent. Failure to co-parent is a big deal. You want to make sure all of that is documented and you can relate that back to whatever text messages or emails there are. And so if you're keeping track on a daily basis of all of these things that are happening, you can easily relate back to
Yeah.
the things that are documented, like the emails and text messages. Keep it on a calendar and make sure that you've got easy access to all of those.
Yeah, you like to I know we all like to think we're gonna remember, like, this was a big fight, I'm definitely gonna remember, but
Yeah,
there's gonna be a lot lost in translation if you don't document kind of in real
right.
time as things are happening, and whether that's, a desk calendar, whether it's a notes app, whether it's a diary, keeping track of dates, times, and even kind of as much as you can remember from verbatim exchanges or even where exactly an exchange took place, like whether it was a text message conversation or an email thread, or whether this was a
Hmm.
phone call, whether it was
Hmm.
recorded or not recorded, where those recordings are if you have access to them. If you're not recording, then assume that he is too, right? Like whether we're talking, Virginia's
Yeah,
a single party consent state. So whether we're talking about a phone call or, one of those visitation exchanges, don't assume that there won't be a record of the things that you're saying and how you're behaving. Then
yeah.
likewise, that he should be behaving that way. I like ideally when conversations are happening in text form so that we can follow them and preferably in one format, whether we're generally text messaging or generally emailing or using a co-parenting app like Our Family Wizard or something like
Yeah.
that, so that there's one place to go and check for these communications. It does get confusing when things are all over the place, but
Hmm.
a written record is helpful. And then just assuming that you are being recorded, whether or not you actually are, and
Yeah.
then behaving that way, because any of this can ultimately come up in court. And a text message being read might sound a lot different in court at 9 a.m. on a Tuesday morning than it did, late on a Friday night when he didn't bring the kids back on time and you were panicked.
Yeah,
So you want to make sure that, I mean, some of these things are just lost in context when you go to court versus when it was actually happening. So you want to make sure that you sound calm and rational, that you're not using insulting language or looking to the court like you're the problem when it comes to co-parenting, just like Ashley said, and just preserving that record as much as possible. Documentation is absolutely key.
absolutely key.
Mhm.
And there are apps that you can download that will keep track of, because text messages have become such an important exhibit to have at trial,
Mhm.
um, that will keep track of each text message that the two of you exchange. So that can be a really important thing to have, just so, for ease of access as you get prepared for trial. Just another tool in the tool belt.
Yeah.
But you want to make sure that you have all of them, because you can bet the other side will.
Yeah, I've seen people using AI for that too, like uploading a
Yes,
bunch of pages of documents and pulling out what's important. Now, obviously, be careful how you rely on AI. And I mean, I know people are using it kind of to go pro se and handle their own cases. Definitely check with a lawyer before you make any, huge reliances on information that you got from a
yes,
computer. But I have seen really good, like a good synthesis of long documents or tons of text messages come through that way. So I would view it as a tool in the toolbox, not necessarily like, the one tool, but a tool that you could
sure.
use, as well as a number of different apps, because the evidence can in some cases be really voluminous. And if you're staying on top of it and you know where to, point your lawyer, it can help save time and save money in terms of, gathering all of that information and everybody being on the same page so that you're prepared on the day of the trial.
That's right. And everybody likes to save time and money, so
Yes, yes. And I think somebody asked me the other day, well,
important.
how, I love that you said a wall count, like a desk calendar. So, it's all right there. But somebody asked me, how do you document? I think it's less important how you document and more important that you document in a way that is easy and efficient for you to do it as it
Yes.
happens. Like
Oh,
if
yeah.
you have to go to your computer and open up an Excel spreadsheet and and you can't do it in real time, some things could get lost. So
Right.
you want to make sure that whatever you're doing, it's not according to how I would organize it or what Ashley might do if it was, her own case that she would order, but that it's quick and easy and that it makes sense for you so that you don't lose valuable information. Because
Yeah.
when things get hard, it seems like, the number of communications increase and the level of toxicity, the meanness, the threats, like those can really escalate. And you don't want to lose any of that in all of the jumble when it becomes so much. You want to be sure
Right.
that you can document all of it. So do it in a way that's easy and effective for you.
Yeah. And we're all busy, so whatever is easiest is always best.
Absolutely.
Yeah,
Absolutely. That doesn't lose any of the valuable information.
that's
But
right.
but yeah. Is there anything else you wanted to add, Ashley? I think this is all really great information.
Think so. I mean, I don't want clients to be afraid of going to court. I know that it can be overwhelming and sometimes scary, but certainly if you have the right attorney, then you're going to be prepared. And I think that um, all of the information shared today will certainly get you closer to being prepared for court.
Yes. I think so
So
too.
it's it can all be very helpful and useful information for you.
It's definitely helpful and
Yeah.
definitely a good idea to talk to an attorney, whether it's Ashley or someone else. Ashley's in court all the time, so she can definitely, represent you well in a divorce or custody case in Virginia. So feel free to check out our website. We're at hoflaw.com, hoflaw.com. We've got 4 free books, a divorce and a custody seminar, tons of blogs and free reports, and more episodes of the podcast. If you want to check out some more episodes or learn about another topic in more depth, definitely do so. That's hoflaw.com, hoflaw.com. Thank you so much to everyone for being here. And thank you, Ashley. I think this was really great.